TVASIA Telugu ప్రేక్షకులందరికీ hello and welcome back to our talk show with experts. మనతో ఉన్నారు మన expert Rahul Reddy garu. Rahul garu, thank you so much for being on the show.
Thanks for inviting, Andy. It's always a pleasure to come and share my knowledge and at the same time gain the knowledge from our audiences. It's very entertaining to help people out. At the same time, as a lawyer, I complete myself when I get more information from the people giving the feedback. So a lawyer is not complete by reading the books and learning the law. They also need to know where the clients are. And this is a very great opportunity that you are providing for me. Thank you very much, Andy.
Thank you so much for your service, Rahul garu. And before we get into our topic for the day, I just wanted to sort of reiterate that any information that you hear on this TVASIA channel, either on Facebook or YouTube or on YUB-TV or through any other channels, should not be construed as legal advice for your specific situation. If you need anything for your specific situation, then we would recommend that you contact an attorney immediately. This is mainly to address and help people, so please do not hold us down to any legal advice as such. On that note, Rahul garu, let's go to this other big news, Armada. Priority dates for EB-2 and EB-3 current in October of 2021 under the new immigration bill. And every week there seems to be one more dhamakedar topic, Armada. So the new bill seems to be eliminating the per country quota, and it's only 30,000 new green cards. Now, how do you predict the dates will be current in October of 2021?
Good question. There are some provisions which, after digging into too much things, it was 365 pages. It was just, we can read the sections properly. I mean, could understand and digest it and connect it to each other out. And then we came to know now that the family members of the main applicants will not be counted in this 170,000 green cards. Not only the family members will not be counted in the 170,000 green cards, the wastage of green cards from 1992 to 2000, the wastage of the green cards that happened will be given to us, and the family members will not be counted towards that. Oh. Now, I said October 2021. The law is becoming effective on October 2021, okay. But the counting of the family members, that means not counting the family members, is becoming effective within 60 days. So assuming if this bill can be passed in April, it will become effective in June. Okay. That means that instead of 140,000, now the 30,000 extra green cards will be given in 2021 October though, but the 140,000 not counting the family members will be effective immediately. That means, will be effective 60 days. That will be this fiscal year. Nitya garu, don't forget that we do have 100,000 extra green cards. Correct. That was given as a bonus to us. Right. So 240,000 green cards, and you don't count the family members, guess what it happened to? It went to almost 550,000 green cards for this year alone. That is 2021 until September. Your more than 5,000 green cards will be allocated only to the employment base if this bill passes through. Now, then we go to the next year. We do have approximately 200,000 extra green cards coming from 1992 to 2000 falling into us, plus 140,000. Now that's 340,000. You don't count the family members in it. That means no spouses. I'm one of the spouse member who has been counted when I got my green card in 1996. So people like me will not be counted towards a number. So that's 340,000. You multiply it by 2.5. That's the normal average that we have because there are spouse and there are kids too. So 2.5. So we are speaking of approximately around 700 to 800,000 green cards to be allocated in the fiscal year of 2022, starting in October. That is the reason why I'm telling the priority dates will be current. When you look into the estimate of number of people who are waiting for the green card, there are not that many number available. So everything will be current for everybody if this bill passes through. So the $1 million question for all of us is that we need to make sure that this bill passes. If this bill passes through, we are hitting a jackpot.
Yeah, so come hello, high water, we have to make sure that this bill passes.
This will pass us through.
Another sort of connected question. So you mentioned about all these green cards that is being processed. And from like a staffing perspective, what do you think, how is it going to affect how many applications I can really process?
We have seen a lot of developments every week. Since the time of Trump administration came in,
Right.
we've been hearing every week bad news.
Hmm.
Now, since the time Biden administration has comes in, and every week we hear a good news.
Right.
Recently, they issued a memo. Kids who are applying for OPT, STEM extension, if they just click a wrong box, their life is gone.
Oh.
And they keep changing their forms every 3 months. You send the form before you get denied. You send the form later on, you get denied. So they issued a memo saying that you should be considerate if there is anything that has been denied because of silly, stupid reason, they're going to take the application back.
Okay.
Now, previous administration was zero tolerance. You forget to click a box, you're out. Instead of any code number that has been put, you don't put a dot, it's out. You do not put NA, it's out. You do not applicable. You do not put none. Let's say, for example, you have 2 kids and you put 2 kids' name. In the 3rd kid name, you left it out empty. They have denied applications because of that. I'm dealing with some of the applications. So practically, I mean, it's very hard for the normal individuals to have these applications getting accepted. They're going through hard times. Now we have a memo that is coming out. We do expect that this administration might waive the interview process. That's going to allow a lot of these applications to be processed in this year as soon as possible. That is the expectation that I do have.
Okay. Well, I hope all of what you're saying comes true and everybody gets their green cards and is happy.
One thing I want to add, Nitya. We need all the people's cooperation, not just you and I speaking on this TV Asia. We need all the people. And at this point of time, we are not in a position to specifically direct where to go, how to contact the congressman or senator. But as things develop, we are going to guide you. We've been coming in TV Asia every week for you. We're going to guide you when to contact the senator, what to contact. It looks like the bill, there are some provisions of the bill that looks to be clearly are going to be passed. There are some provisions of the bill that clearly have a lot of objections. There are some provisions of the bill that looks to be, okay, kind of thing. Now, the employment base doesn't fall into clearly possible or clearly deniable. Okay. It looks to be somewhere in between though. So we need a push up there. The DACA kids, what we call is where children came under 15 years old, they are unlawful in this country. That seems to be the one that looks to be, everybody is poised to get that one approved. But when it comes to the employment base, we need a push up. I expect all the audiences to, help us out in pushing it to help themselves out. But we'll give more clear guidance as we proceed at a later date.
I hope so. And fingers crossed. Thank you so much for the information, Rahul Garu. And on that note, let's move on to our callers. Let's take our first caller for the day. And while we're getting them on, there's a question from Sebastian. He says he got his citizenship last year and has applied for an immigrant visa green card for his parents. The petition has been approved and they're going to schedule the interview in Mumbai. He says his parents don't know English and is wondering if it'll impact the immigration interview or should they change the center to Chennai instead of Mumbai?
One thing is that the family immigration is only Mumbai. It's not Chennai though.
Okay.
So they're forced to go to Mumbai. But believe me, there are translators in Mumbai consulate. If your mother is speaking in Kerala, Tamil, Telugu, Andhra, whatever language Telugu or Kannada, there are people who are translators, not a big issue. She is allowed to take the translator. She or he is allowed to take the translator. But most probably what will happen is that they may say that we have consular officers who speak the language, so we may not need the translators, and they may tell them to stop outside, which is fine. I am pretty sure that the Mumbai consulate has the people that speak all 13 languages. Now, if they fall into any of the rare languages that they don't speak, For example, in Telugu, we have Lambada language, and there are some people who don't speak that language. Those kind of people are where we need translator. But for typical South Indian languages, you do not need a translator. There are people who speak that language. There are no my translator.
Awesome, Andy. Thank you so much. All right, let's go to a caller. Sir, area code 318. We're ready for you now.
Hi, Rahul Garu. I have a couple of questions. My wife's H4 is valid till July 19, 2021, and she's working right now on the EAD. And I got my H1B extension approved for another 3 years, and her EAD, H4 and EAD is still pending, and it's been 1 month since she applied it. She had a plan to go to India to attend a meeting in May, and if she goes to, she's planning to go for a stamping. And if she goes for a H4 stamping, does the current H4 application gets abandoned? And what happens for the EAD?
No, the H4 application does not get abandoned. There are a lot of things that are flying around. Since it's an H4 extension, it does not get abandoned. She is still entitled for H4 visa there. Let her come back, and the H4 and EAD will be adjudicated accordingly. When it gets abandoned, if you look into internet though, it will tell that it gets abandoned. It is true in the case when you file it as a change of status to H4. Since your wife has filed a extension of status, it is not abandoned, and the H4 and EAD will be adjudicated accordingly. She technically don't, we both know that she doesn't need H4. You're only worried about EAD, I know that. It won't be abandoned, it will be adjudicated accordingly. She can go and come back.
Okay, sure, thank you. I have one other question. If we want to go for a H4 EAD litigation, does she needs to be in USA to do that?
No,
because
she doesn't need to be in USA to go for the H4 EAD litigation.
Yeah, why? Because we want to go for litigation in the last 2 months before it expires.
Okay.
And she will be in.
That's fine.
India.
I said she can be in India. Okay. Thank you very much. Okay.
Thank you.
Let's take our next caller, Andy. In the meantime, we have a question from Somnath Roy. Says, can adjustment of status EAD be expedited? Reason being H4 EAD expiry and leading to loss of ongoing job. Is adjustment of status EAD impacted by biometrics backlog?
One thing is, a lot of people are in the room. Biometrics has nothing to do with EAD. I'm speaking of only adjustment of status EAD, guys, not the H4 EAD. H4 EAD definitely is connected with the biometrics. When it comes to the adjustment of status, it is not connected with biometrics. So you can request the expedited processing of the EAD because of biometrics of H4, that your wife H4 EAD is stuck there. I doubt if they would do it. I doubt, but you can request. There's nothing wrong in requesting. The chance of success is very rare. That's all I can tell you.
Okay. Thank you, Rahul Garu. Let's go to our next caller, Andy. So area code 917, we're ready for you now. Sir, *6 to unmute. Hello?
Hello?
Let's open, sir.
We can hear you.
Hello, sir. Yeah, hi, Andy. Good afternoon to you both.
Sure.
Sir, my H1 approved in consular processing back in August 2020, and since then I was in India and working as a freelancer to the client through an implementation partner, and my visa got approved on February 22nd, and they gave it for 3 years actually, which is a very good news for me. Can I continue to work as a freelancer from India for some more time, or is there any rule once H1 is approved or visa is stamped, it should not be...
The only problem is that if you come after a long time though, the CBP officials may question whether or not there is a genuine job opportunity open in USA. Is this a position that is in USA? Is it a position that is in India that you're trying to come here? If the position is in India, why are you trying to come here on H1B? When you went for the stamping in February, you told you have a job in USA. Please give me the visa. And your company said they have a job in USA. Now, your long absence outside the country is not doing justice, though. I would strongly recommend that you try to come as early as possible. Don't delay. Just because of some financial gain or other reasons, don't delay. Try to come as soon as possible.
Sir, like my appointment is in March, but it
I thought
might
you said you
slide
got this.
little bit like to April.
I thought you said you got the stamping.
Stamping is done, and the appointment letter from client says like the on-site position opens in March, mid of March.
Okay, then yeah. If you're delaying by a month or two, I'm not worried. You're fine. I'm speaking about if you delay by 2 or 3 or 4 months, that I'm worried about.
Sir, I have little tailed piggyback question actually. Like my passport is expiring in July of this year, like my Indian passport. Can I apply for another 10 years extension and come with that passport, old and new one?
Absolutely not a problem. Make sure that when you come here, carry the old passport and new passport. Just because you got the stamping on the old passport, it is not going to cause any problem whatsoever at all if you have a new passport that is expiring. They will look into the new passport and they will look into the old passport. That is perfectly good. Thank you.
Awesome, sir. Good news. Thank you so much.
Thank you, sir.
Thanks,
Thank you
Rahul.
for calling. All
Thank
right.
you.
Our next caller.
Thanks, TVA.
Thanks, sir. Okay. While we take our next caller, Andy, Rahul Garu, there's a question from Be Kind. He says, after 180 days of an approved EAD with employer A, can a person resign that job and start his own new company with the same EAD, or should the main applicant work for another employer until he gets a green card?
The main applicant has to work with an employer until he gets a green card. There are some restrictions with regards to he and his family member opening a business and working for that company. I'm not saying no to it. There are some limitations, though, that they need to understand. It's not clearly, there's some gray area. There is some black and white area in there. For sure, I can assure you that you must have one job that is in the similar profession of what you have been filed a labor certification application, and the new company has to file a 485J supplement. Now, is there situations where the wife opens the company and employs the husband and the wife files a 485J supplement? We have done that. It always raises some question when the wife is the owner of the company and she signs for the 485J supplement. Nothing illegal, though, nothing illegal. It raises questions, and it raises, a lot of times we had to go to the USCIS office. We have to explain to the official it is perfectly legal. The labor certification rules that the relative cannot be part of the ownership does not apply to 485J supplement. We have to defend it. It becomes a little bit more complex, but it can be doable too. In general, I would like people to avoid, try to work for a different company and get the 485J supplement. Now, on a moonlight thing. Now, this moonlighting is invented by doctors where they have a one main job and they go to other clinics. They call that as a moonlight thing. Right. So you can moonlight too. I mean, you can have a main job and you can moonlight. That is fine. But leaving the main job, going to another job, which is not in the same profession and which is owned by yourself, definitely poses some risk for you.
So Rahul Garu, this sounds like one of those things which needs a consultation with an...
Right. Especially if he wants to leave the main job, then he definitely needs to consult.
Yeah, that makes sense. Okay. Thank you, Rahul Garu. Let's go to our caller, Andy. Sir, area code 864. We're ready for you now.
Yeah, hi. My name is Abhinav. Can you guys hear me?
Yes, we can.
Yes, Abhinav.
Go ahead.
Yes. So my first question is, do you know of any case where someone lost their status because their EAD didn't get renewed in time? Just because, the wait time that these guys have, like there's a huge backlog.
Absolutely good question. You're speaking about adjustment of status EAD extension, is that right?
Yeah.
Okay. You already know the rule that if the EAD extension is pending, you can work up to 180 days. You already know the rule. If the extension is filed in the proper timing. Now the question is that what if the EAD is not been filed before it expired, or what if after 180 days also if the EAD is not approved? That's your question. Very good question.
Correct.
Let me tell you one thing. Very, very, very good question. They do not lose the status. Your status is adjustment of status. Your status is not EAD. Now, you are forced to stop working in that period of time. When your EAD has crossed 180 days, you're forced to stop working, but you're not out of status. You're still in status. You see my point?
Yes, yes, I do.
Yeah. It will only, you just have to pause for a while until you get the EAD, but you are still in legal status, not a problem for it.
Got it. And my second question is, I have a EAD, green card EAD, and I'm also on H1. If I do an H1 transfer to another company, do they have to file PERM and I-140 again or not?
No, absolutely not. Unless the only purpose of you living is to make the immigration lawyers. No, you don't need PERM and I-140 at all. I'm assuming that the 485 has been filed for more than 180 days ago. I'm assuming your I-140 is already approved. In that case, they just need to file a 485J supplement, which is very easy, doesn't require any advertisement, it doesn't have any filing fees. But definitely do not need to file a PERM and I-140. Absolutely not needed. Now, the question is about the H1B. Do you need the H1B? I mean, if your purpose is to have a house like, for the immigration lawyers house like this, it's a fake, guys. It's just a virtual background. Yeah, then you can, I would continue on H1B and EAD. But if your purpose is not to make lawyers like us this big house, you may choose to avoid the H1B completely and just go with the 485J supplement.
Sounds good. Thank you so much. Appreciate you taking the call.
Thank you.
All right, let's take our next caller, Randy. And meantime, we have a question from Sumit Anand. He says, had an I-140 approved in 2014 with company A that filed for bankruptcy in 2018. And in 2019, new company name emerged and I had to transfer the H1B with the new name. Do I need to file PERM again? Role and the team is same.
It is a little bit risky though, that this I-140 may not be approved. There is a chance for it. Okay. The reason is that the company, when the USCIS looks into the second I-140, they want to see a continuation of the job offer. They want to see a continuation of the ability to pay for the particular individual though. Since he said that the company has been declared insolvency, there is a risky element in there. I'm not telling that it's a straight no. If I were him, I would do two things. I would definitely file an I-140 right now and do the premium processing without using a new PERM and without using an new I-140. I would try to do it. If that's not successful, then I'm going to file a PERM and I-140 with a new company. New name of the company. Now, he doesn't have to wait until the I-140 gets denied if he wants to be a little bit precautious. He can file an I-140 with the previous company's labor and I-140 with new company's name. At the same time, start a new PERM with this new name. In that way, he can save some time.
Okay, fair enough.
Especially time is very important, Nithya Garu, right now, because if the bill goes through, remember, priority date is going to be current in October of 2021. Yeah.
Time is of the essence. Thank you, Rahul Garu. Let's go to our caller, Andy. So area code 734, we're ready for you now.
Hello, sir. Hello, Nithya Garu. Thanks for the great show.
Hi, ma'am. Please go ahead.
Thank you.
So my question is regarding EB-1C, the 1 in 3 year rule. So I'll tell you my situation and please let me know if I'm eligible for it. So I was working in company A in India from 2015 December to 2019 Jan. That is approximately 3 years, that is until 2019 Jan. And then I came to US in L2 in March of 2019.
Did you come in with company A or with a different company? Did you come with company
No,
A
I came on L2. No, sir, I came as a dependent of my husband. Yeah, so I was not having a job at that time. So I got my EAD in June 2019. And then I joined the same company again in US after a break of about 4.5 months. So my company did my L1B visa and then it got approved in April 2020. And then I recently upgraded to L1A, and it was approved in Jan 2021. So my company is planning to file EB-1C for me. So I want to know if I'm eligible. So the rule is I have to work for 1 year in the foreign company, either before entering US or before applying the petition. So I was on a break for 4.5 months in US after the non-immigrant admission. So and then I got
absolutely not a problem. You can apply for EB-1C. And there are 2 times it's already evidence that you meet the qualification of working 1 year out of the past 3 years preceding to coming into the United States. If you are not eligible for EB-1C, your L1B, I mean, I'm only speaking of the 1 year working requirement, okay? There are a lot of other requirements. We're only speaking about the 1 year requirement. If you don't meet the 3 out of 1 year requirement though, your L1B should have been denied. If you don't meet the 1 out of the 3 years requirement, your L1A should have been denied. You have already proved 2 times you meet the requirement. So I have no doubt you will be fine in that aspect. Of course, there are other aspects we are not going to discuss, but that's that single aspect you already qualify.
Okay, because I was having a break, so that's the reason I had the doubt if it should be a continuous employment.
You're fine. You're absolutely fine. No problem with 4.5 months.
Thank you.
Thank you.
Thank you, sir. And I just have a small question. So I know recently the premium processing for EB-1C, I-140 was approved. I mean, the bill was passed, but it is still not implemented by USCIS. So is there any chance that it will be implemented soon?
These kind of nice things are getting implemented very much. And of course, this is a money thing which immigration requires money. I'm anticipating it should be coming soon. That's my guess, but it's been like 8 months that the bill has been passed though.
Okay.
Okay. Thank you very much.
Okay, sir. Thank you. Thank you so much, Nitya Garu.
Thank you, Andy. Thank you so much for calling. And let's take our next caller. And in the meantime, we have a question from Janvar Harish. He says, is it possible to move to consular processing after getting the EAD? Priority date is September of 2014. It's a straight EB-3 application. Please let me know the pros and cons. Appreciate your help.
There are a lot of cons than pros. One thing is that once you leave the country, you are abandoning the adjustment status. Then you have to file something called I-824 application for your I-140, which takes almost like 2 years to adjudicate. Then it has to go to the consular processing. Definitely, there are a lot of moving parts in this one. One is withdrawing the 485 application. Second is filing an I-824 and then having this one move to the consular processing. In all these things, the company has to cooperate completely though. And then a lot of judgments will be made. Why are you, the reason why they are giving you the green card, the US government is giving you the green card is you want to stay in you want to stay in this country. You have a permanent offer in United States. Wait a minute. Weren't you working here? Why did you move back when you have a job? You have an EAD. Why did you move back? So these all questions need to be answered and they will be questioned very much. And when you go to the consular office, they will question very much. If you can avoid it, I would like you to avoid it. Otherwise, it can be transferred, but it's a little bit more complex.
Thank you so much. All right, let's go to a caller, Rahul Garu. So area code 302, we're ready for you now.
Hey, hi, you can...
Oh, we were, but *6 to unmute your line.
Hey, you guys can hear me?
We can hear you.
Yes.
Please go ahead.
Hey, hi. Thanks for helping Nitya and Rahul for the community.
Sure.
So let me talk in Telugu so it's better to understand. So in my case, so right now I'm in H1, Rahul Garu. So I'm applying my extension next month. Sorry. So my wife, we are planning to send my wife to Mexico for the stamping, H4 stamping. Is it a good way, is the best way to send her to Mexico or India?
I'm fine with either sending to Mexico or India. Either way, it's fine. It doesn't make much difference in that. I know your purpose is to get the EAD faster, right?
Yes.
Yeah.
So
It doesn't
I
make
heard
any
from
difference.
one of my friend. Yeah, I heard from one of my friends that the biometrics need to be done in the US. Is it?
No.
Is it true?
If you're getting the stamping in India, or if you're getting the stamping in Mexico, you must, your wife should be getting the biometrics done in that respective consulate only. It cannot be done in USA. No.
Okay, that's great. And the other question was regarding my 140. My priority date was like 2016. So actually, I want to do in EB3 as well. So I asked my employer regarding this. So he told this will be the big issue and it will be the headache, if you do it in EB3. So I was confused.
Let me ask you this question though. You have had people whose priority date is before January 1st of 2015 in your companies, right? Did they converted their EB2 into EB3 and file the adjustment of status in October?
See, this is the thing that my employer told me. What he's telling, so he had like 100 people. In 100 people, 20 to 30% people got qualified for the downgrade, but he advised a lot of people to not to downgrade. And couple people got forcefully.
Everybody will be eligible for downgrade. There's no qualification required for downgrade. If you want to upgrade yourself, there is qualification required. This is like this. If you can climb 100 floors in 1 hour, okay? Let's say I proved to the USCIS, everybody is satisfied that on January 1st of 2015, let's say on December 31st of 2014, I proved that John Doe was able to climb 100 floors in 1 hour, okay? Now I am going back on December 31st of 2014. John Doe I just have to prove he was able to climb 50 floors in 1 hour. I already proved 100 floors. And what does he need? Everybody is qualified. Now, if I proved on December 31st of 2014 that John Doe only climbed 50 floors, and then I have to prove that on December 31st, 2014, he can climb 100 floors. There are a lot of things, moving parts that are required, okay? But when it is proven that you already have gone to 100 floors, I just have to prove 50 floors. It's so easy. Everybody is qualified. I see something is wrong with your company or your company's lawyer. Hundreds of thousands of people have converted into EB3. Everybody is qualified. Now, why is your company is doing wrong things? I see something wrong with your company. And I have to speak this particular sentence. I have to speak this particular sentence in Hindi. Dal mein kuch kala hai.
So Rahul, this is happening exactly, So me chana help chestunar community ki, that's for sure. Everyone is really happy with you, but a lot of
we have to get to the topic.
Yeah. So employees are not happy with that, So that's what I want to tell you. So
definitely the company and the company lawyer is not good. So our company is not good. You may want to change the company. I don't know. If the bill doesn't go through, you may be stuck with this company for a long period of time.
Yeah. Last question. So do I need to start with with labor, or my 140 is okay? I mean, the labor certification is okay.
Your I-140 your labor is absolutely okay for doing EB3. I have not even seen it, but I can tell that. It's just something, dal mein kala is your company has something wrong with it. Okay?
Yeah.
Thank you.
Yeah. Thanks a lot. Well, thanks so much.
Thank you for calling. And on that note, let's take a quick commercial break. We'll be right back, folks. Folks, welcome back. The excitement continues. Let's move on to our next caller. And in the meantime, we have a question from Kumar Verma. He says, can a person on STEM OPT start a business from DE state? I'm thinking that's Delaware, IT consulting company.
No. You cannot start. There is restrictions with regards to your employment on the OPT and STEM extension. It does not allow you to start a company. There are under some limited circumstances where you can have the ownership in the company though. But my problem is any involvement of yours will be construed as a violation of the immigration status. So I not only recommend OPT and H1B students to be not investing in consulting companies. Yeah, they can investing in Microsoft, Google, or my favorite Tesla or something like that, but definitely not in a consulting company, because there will be an involvement of you, and that is not allowed on your OPT STEM extension or H1B rules.
Thank you, Rahul Garu. And on that note, let's move to our next caller, Andy. Sir, area code 813, we're ready for you now.
Hi, Rahul Garu. This is Krishna.
Yes, Krishna.
My question is, I have applied for my wife's H4 extension on December 29th, but I did not receive the receipt notice till now. And I got a mail from my employer also. Like I reached out to my employer, and they came back saying that even the checks were not encashed, and they asked me to call the USCIS like customer care. I called them.
Which address did you send to? Texas or Phoenix? Do you remember which address you sent to?
I think, yeah, I think it's Texas.
Okay, welcome to Texas. I'm from Texas. It's not odd that is happening with you. We have noticed that the applications are still pending. I'm not telling that yours is perfectly okay, but what I'm telling is that there are a lot of people in the same boat like you that have filed in the last week of December. They are still pending. It took a while for them to move from October because of the number of filings. But once they moved from October, though, they moved November in just 1 week. The entire November has been covered. So they're in December. I'm hoping that by next week, you should be receiving the receipt notice. That's my hope. But you're not alone. There are thousands and thousands of people.
Okay. Yeah, that's a question. I'm a little worried actually, because my employer himself came.
I understand, but there is not much can be done right now other than keep contacting Emma, and then she will keep telling you. You know who Emma is.
Okay.
Emma is the online bot for USCIS, just in case some people don't know.
Okay.
Okay, thank you.
Thank you, sir.
Thank you very much.
Yeah, thank you. Thank you, Dr.
All the very best. All right, let's go to our next caller, Andy. And in the meantime, we have a question from Ravi Oak. Says, filed I-140 amendment and 485 in October 2020. The amendment is due to company takeover after original I-140 had been approved about 5 years ago. What if this 140 amendment gets denied? Is everything lost, including priority date? Or can the original I-140 be at least used for H1 extension beyond 6 years?
It depends on why I-140 has been denied.
Okay.
When the I-140 RFP will be issued, though, at that point of time, we can categorically avoid the situation of getting the I-140 denied, to see what are the circumstances the I-140 can be approved. What are the circumstances I-140 can be denied? What if it denied? Will it impact the previous I-140? Will have to be evaluated when and if the RFP comes in. If, for example, if there is some degree certificate or some experience letters or some things like that, it may affect the previous I-140. So I'll be very worried about it. I would say in general, though, without looking into the RFP that has been issued under the EB-3, there is less than 5% chance that they will go back and revoke the previous I-140. That means that 95% of the time, you would be able to use the previous I-140 for all purposes. Only 5% of the time that we see that the denial of this one will affect the previous I-140.
Okay, makes sense. All right, thank you, Rahul Garu. Let's go to our caller. So area code 816, we're ready for you now.
Hello, Nitya Garu. Hello.
Hello, sir. Sir, *6 press to unmute your phone line.
Can you hear me now?
We can hear you now. Please go ahead.
Hello, Rahul sir. So my brother came to USA in 2009 on H1B visa. He was working for a year or two, and then he came. He went back to India, for family-related things. Now he is planning to come back to US. So question is, does he need a new H1B or can he transfer his H1B to some other employer?
He doesn't need a new H1B. The reason is that to be counted towards a lottery, he must have had been stamped on the H1B or must have been in USA on an I-94. You told me that your brother was here on H1B in 2009. That means that he had an I-94. Of course, he didn't jump the wall to come here. So he's been counted towards the H1B number. He doesn't need to be counted in the H1B number until his life. The only minus point that you get, which I know you won't care, is that you told me that he spent 2 years on H1B. If you don't apply in the lottery, he will be only eligible for the 4 years of the H1B. Obviously, you know, to file a labor I-140 and get it extended, but he will be entitled for 4 years. Absolutely, he can come, no problem with it.
Thank you, sir. And next question is, I'm working on Company B, and my previous employer, I had approved I-140 in 2019. It's more than 180 days. In Company B, they started my green card processing, but with current scenario, if at all the priority date becomes current for 2019, like if I don't have approved I-140 application in Company B,
at least labor approved,
Yeah. So will there any issue for me to extend my H1B?
No, I'm not
right
expecting
now.
any problem. I'm not expecting any problem in extending the H1B. Sometimes you may miss the boat that is available, but I'm not expecting any problem with your H1B extension. So in 2000, let's say in October of 2021, the priority date becomes current. You don't have a labor approved with your current company. You can extend the H1B. I don't see any problem in that.
So as long as we have approved 180 days petition, we can extend the H1B until we get.
That is right. Just like the way your brother doesn't need to be counted for his life, you can keep on extending the H1B for your life. You're good.
Got it, sir. So only perm is should be approved, or like both I-140 also should be approved if there is a
as we discussed.
priority.
If the priority date becomes current, only perm needs to approve. Why do I say that? You can file I-140 and adjustment of status on the same time. You don't have to wait for I-140 approval. You club both of them. Remember in October, a lot of what we did with a lot of people, we didn't have EB-3 approval for them. So what we did, we filed I-140 and adjustment of status. So in your case, your priority date is 2019. If it becomes current, you have a perm approval, boom, you file an I-140 and adjustment of status.
My privileging wage submitted in November, sir. Do you expect to get that in next 1-2 months?
Prevailing wage is taking approximately 4 months to 5 months nowadays for now. Wow. So that will be somewhere in March or April,
Okay. Thank you, sir. That's all my questions.
Thank you very much.
Thank you, नीतिका.
Thank you for calling, sir. All right. Let's go to our next caller. But in the meantime, Rahul V, this is an interesting question. This is from Bobby Manuel. He says, in the U.S. Citizenship Act of 2021, does this have any provision for F1 visa and aged out kids?
One is the aging out of the kids. There is a good provision there. If the person was being issued a H4 visa when they are under 18 years old, their age is secure, so they will be able to get the green card. So that's a very good protection that the immigration bill has. In the student visas, though, there is a provision there that if people are coming into United States for STEM degrees, that means science, technology, engineering, and medicine. If they are coming for those things, they will be considering those students as a dual intent visas. Now, to explain what a dual intent visa means, if a person has at this point of time, the rule of a student visa is, the student visa must have, applicant must have only intention to come and study and leave the country after the person comes into United States. But if they have any intention to settle in United States, their F1 will be denied. And 95% of the F1 denials are only because the immigration, the consular officer feels that they're going to settle in United States. So the STEM extension people will not have that restriction. So most probably they cannot be denied. So this is applicable to all the people. So it's a very good thing. The F1 student visa denials will go down very significantly if this bill goes through because of the dual intent.
Okay, that's good. That's so good, Andy. Rahul Garu, let's move on to our next caller. So area code 630, we're ready for you now.
Hello, Rahul Garu.
Hi.
Hello,
Can you
sir.
hear me?
Yeah.
Yes, I can.
My question, you have any update on the recent 485 rejection cases, resubmission? Many people, I think you are aware of that. Many people
Not yet. Not yet. Most of these things have been filed in January. Remember, I was speaking about the other gentleman. The receipt notices are done until November. Priority dates for all the people were currently November too. So we are now entering December, which is also, we are very less people. So once we enter into January, we will be able to get some good results. The good thing, what is coming out right now is the recent memo that came out on the OPT and STEM extension. Remember that I was speaking before at about 10 minutes in this video that I told that even if it's been, if the STEM extension or OPT has been rejected for stupid reasons, they should be taking it back. And that they have written it officially. I mean, sometimes they do unofficially, but this government went on publicizing that. When you have something published, you have that thing and going after the immigration, hey, you know, this is a stupid reason, you take it back. There is a good chance that there is a lot of pressure from the American Immigration Lawyers Association and a lot of people, and this administration is quite different than the previous administration. We are anticipating, and I know the reason, one of the reasons why it's been denied is the 4th or 5th page, where some of the lawyers didn't pick up those 3 boxes out. That's the reason why it's been rejected. And it's been vaguely done. Yeah, so I am expecting that they will take it. That's my assumption. But, you know, we'll keep updating you. Every week we are there. You come here, we'll update you. As of now, I'm thinking more positively. Let's see what goes on. We'll be able to come to know in the next 2 weeks.
What I wonder is, usually when we do the mistake, we take help of the attorneys. In this case, in our cases, attorneys did the mistake. Now we do not understand whose steps we have to take.
Yeah, I mean, we read it, and of course, you know, in our office we did not do that mistake. And it's a lot of lawyers have picked those boxes. They didn't pick those boxes before. They got their things selected. Didn't have any problem. But just at the crucial moment of the time, this is just like the way, remember the Arjun and Karan Yuddha happens? Everything failed at that time. And that's what exactly happened. They used every technique to deny every application possible in October. I mean, that's what happened.
Anyway, end of the day, we will all come to all your attorneys, take out our situation, because you put in if you all put in this
situation, you have to take out. Well, we have, I have not done it. End of the day. We did not do the mistake. We did not do the mistake, but I'm not going to be completely saying that your lawyer is the dumbest. I would not say that thing. I will not say that. Well, you know, we are in the same profession. Yeah. So I understand your frustration. I really understand your frustration. I've been there. Remember, I got the green card the same way what you are trying to get. But let's hope in 2 weeks how things will turn out. Okay? Thank you.
Thank you very much. I appreciate it.
All right. Thank you, sir. Thank you. Let's go on to our next caller, Andy. And we have a question from 𝗧𝗔𝗟𝗞. She says, moving to a new house after 6 months within the same city, adjustment of status filed in October of 2020. Does the change of address have any impact on the 485 process? She says she will submit an AR11 with USCIS within 10 days of the address change.
That's a good thing. Nowadays, with AR11 being online, though, we haven't noticed a lot of problems. Okay. Like the way we used to do before when the online was not there. Right. So when people do AR11, I want to make sure, ma'am, you need to point out all the applications that are pending. Mm-hmm. If you have H4, H1, EAD, you have an advanced parole, you have an adjustment of status. Sometimes they do have a 485J supplement separate issue. Make sure that you put all the numbers out there. And they're doing very good, though. I mean, very thankfully, they're doing very good in address change. Previously, it was a nightmare for us to get the address change. We haven't been noticing much problems in the address change.
Awesome.
And I love the girl Emma in USCIS. I mean, out of all the people that I she's been doing a great service. I love that girl. After they started implementing Emma, the robot, believe me, a lot of issues have been resolved. A lot of clients calling every day, is my check cash, is my check cash? We tell, hey, go ahead, chat with Emma. And they're chatting with Emma, and then they're getting, hey, I got my receipt notice. So by the time we look into the bank, so things, they're doing very slowly, but they're doing good.
Well, on that note, let's go to our next caller. So area code 361, we're ready for you now.
Hi, Rahul Garu.
Hello, sir. Please go ahead.
Currently, I'm working with company B. With company A, my I-140 was approved and priority date is September 2015. In case if my priority date becomes current in October 2021, so and if if employer A is a consulting company, if employer A is willing to file my 485, can my employer A do it like 485 without I join there in October? If I join sometime in November,
they can. They have done a lot of in October of 2020. A lot of companies have done. We did not expect any. Things should be fine. A lot of people have done in October of 2020, and if your company is willing to, you can still file adjustment of status with your previous company.
But,
although I strongly recommend that you start the process with your company, the company A can still file the adjustment of status for you.
Sure. You want me to start processing with company B?
Yes, absolutely. It'll be much better for you to file an adjustment of status but with the company B rather than company A. Company B will always be willing to, but under the circumstances where you don't have any option, you can still go to company and company A can still file it.
The reason why I'm asking, company B is a different client. It's a product-based company, so I'm full-time there.
I still want you to have the company B file the labor certification. I don't want to rely completely on the company that you resigned and you said, I don't want your job. And now you want to go back and you want them to do a favor. Surprisingly, a lot of consulting companies did a lot of favors to the people. A lot of people complain about consulting companies. I don't have that many complaints. Look at how many number of people have filed, even though they left the company though. If you are working with a product-based company and they're not filing a POM and I-140 though, I don't want you to completely rely on company A. I want you to move out of company B. In the long run, it's not advisable to stay with a company that is not filing you for the labor and I-140, especially when the dates are moving so fast.
Sure.
Thank you.
Okay, thank you so much.
Thank you, sir.
Thank you, Nitya Garu.
Thank you so much for calling. All right, let's take our next caller, Andy. And in the meantime, we have a question from Imani. He says, I'm applying for an H-1B visa this year, and if it gets approved, by the same time, if the date gets current, do I have to be on H1 or can I apply for an EAD? My I-140 is approved and my priority date is 25th. Thank you so much for calling.
What did he say?
One second. So, sir, area code 817, please press *6 to mute your line only. Thank you, sir.
Yeah.
All right.
Hello? Hello?
Sir, can you just hold on for 1 second, sir? Mute your voice only and mute your TV line also, sir. Thank you.
Hello? Yeah.
Thank you, sir. Hold on now. Rahul Garu, this question is from Anmol Meghani, I said. Said he's applying for his...
I know. If he's filing for H1B, he has his I-140 approved. So if the priority date becomes current, does he need to be an H1B? No, he doesn't have to be an H1B. You can file adjustment of status directly from your student visa to the adjustment of status. You don't need H1B. Especially though, I know that nowadays for Indian nationals that things are moving faster. Who knows, this bill might go through. But for non-Indian nationals, we always try to avoid H1B. Why pay all the fees to the lawyers and make them rich? Just let's file the labor. They have 3-year period. File a labor certification. Their priority date is always current. And file the adjustment of status to get an EAD. We can avoid completely H1B though. Yeah, I hope this will pass through, and I hope you do not need to be on H1B to file an adjustment of status.
All right, Andy. Let's go to our caller. So area code 817, we're ready for you now.
Yeah, hi. Hi, Nitya Garu and Rahul Garu. So my question is, so basically we applied for the adjustment of status on in October 26th. So it was supposed to reach the, it was showing as a, to be reached on 26th, but it did not reach when we were checking the tracker. So after a couple of days, my lawyer suggested to file another set of application. So we went on with that one as well. So it did not also went as like, on the next day, basically. So on Friday or Saturday, both the applications, the first set and the second set, went to the USCIS. So my lawyer suggested to cancel the second set of check stop payment to the second set of the application. So we waited to after receiving the first set in December, I put a stop payment to the second set of the application. But in the first set of application, the form 765 was wrong and it got rejected. But the 485 and the I-131 was both were, I got the receipts for them. So we applied for the second, for the EAD 765, 765 and it reached on January 6th. But strangely, even after doing the stop payment, we got the second set for receipts for the second set of the application, all the three of them in January.
What about the checks?
So my question is, I did the stop payment. It did not go through. But I got the receipt saying that they got the payment.
Yeah, your lawyer was right in one thing and wrong in another thing. Right in not taking the chances, because if he had some issue, he didn't want to take chances. He wanted to spend your extra money and then file a second set of application, which I would have done it too if I were your lawyer. Sending stop payment is not a nice thing to doing with immigration because they didn't do anything wrong. They filed the application. They're going to come up, if the check has been rejected, they're going to come up with a collection. I want you to do one thing, just pay them the money, okay? Don't try to resist it. Pay them the money and withdraw the application, second application. Don't tell them that they are
more
wrong.
Than like, okay, I just have to take up the stop payment thing on that.
Right, if you can do it, do it. If you can do it,
okay.
Take the stop payment off. Don't risk it, okay? You can always withdraw it later on. No problem with it. But don't do the stop payment.
Can I just straight away go and withdraw the application, sir? Straight away?
You don't have to withdraw. You don't withdraw right now. Just hold on right now. Just get out of the sync right now. Go for, take the stop payment off. And when they come for the collection, make the payment, then withdraw it. Don't withdraw it right now. Everything is getting confused there. The check is not cash, you have a receipt notice. So first, make sure that you take care of the payment. Once the payment is taken care, you can withdraw it after that.
Okay, because it's been like in January, right? So I'm not sure, like I can.
Well, you just got,
but
you just got cash.
I got it in. Yeah, I got the receipt on January 23rd or 24th.
Do it. Don't make sure that you don't withdraw it right now, sir, without consulting a proper lawyer, okay? Okay.
Sure. Yeah. Thank you, sir. Yeah.
Thank you, sir. Thank you so much for calling. Rahul, we have another question before we take our caller. This is from 𝗟𝗡𝗪 𝗪𝗧𝗛. Says, is MCA from India equal to MS from US?
Yes, it is. It is a 3-year degree after a 3-year degree or 4-year degree. So definitely it's a 6-year thing. So it is equivalent to MS in USA for the purpose of the master's degree in I-140 and H1B.
Thank you, Rahul Garu. We'll put our next caller, Andy. So area code 201, we're ready for you now.
Hello.
Hello.
Yes.
Hi, can you hear me?
Yes, sir.
Hi, sir. Yeah, so my question is, I applied for concurrent EB2 processing in October, and I received my receipt date in January.
Did you file concurrent EB2 or concurrent EB3?
Concurrent EB2. So the question I have is, like, I have currently a standing offer with another company. So my 180 days completion would be around the end of April. And so right now I received the receipt notice even for my 140. So I mean, do you advise, should I mean, because if I need to go to another company, my 140 should be approved, is the condition, correct? So in that case, I mean,
thing I want to clarify, again, I asked you this question.
Yes.
Is it concurrently EB3 or EB2? You said EB2 two times.
No, EB2, you're right. It's EB2 only.
But did you file an I-140 for EB2?
Yes, correct. EB2.
So previously it was EB3 that you have an approval?
No, previously also it was EB2. So my company still filed it for EB2 only again. Another I-140
wait,
application.
I didn't understand. I didn't understand. Let's speak about I-140 first.
Sure.
If you had an EB2 approval, why did you file another EB2 I-140?
So based on what my company, I mean, immigration lawyers mentioned was like, my I-140 application when it was filed in 2010 December, it had some conditions where like, it was not flexible enough, or like, the I-140, the latest I-140 has more flexibility in terms of
so did you
location.
Did you file another POM application to file this I-140?
No, it was just an I-140 only.
Dal mein kuch kala hai. There's something wrong here.
Okay. I mean, so I mean, from based on so all the employers, all the employees of my company, ours is a consulting company, and all the employees who were eligible for filing the register of status in October, everybody had to go through the same thing.
Okay, I want to leave this I-140 concurrent thing aside though right now, because I need to understand the underlying logic. I need to see because POM has not changed. How does the conditions in the I-140 change? I don't understand it. There are some times where there is a weak documentation of the POM where they do not put that you can work in unanticipated locations. For that reason, we tell people to file one more POM application. But if they didn't file one more POM application, what is that they have done here? It's the same POM that you use, same company though. So I don't know what it is. Or if I leave that one out, okay, I'm assuming that your I-140 will be approved also, okay? If you have a job offer, assuming that your I-140 will be approved, okay? Within 180 days, even if somebody puts a $500,000 cash, and they will tell that if I take the cash, they're going to pay the income taxes also for it. I am not taking that offer.
Okay.
Is that clear to you?
So actually that is clear. So my question actually is like
okay.
So as I mentioned, the 180 days would be around end of April, and do you think I should initiate a premium processing for this I-140 application?
I want everybody whose kids are not teenagers to apply for premium processing. Period. Okay. No questions in it.
So I already have talked to my company and asked them to initiate the premium processing for I-140. They mentioned the 6 months would be just around April. So if we initiate premium processing, again there might be a chance of an RFP possibility. So they were actually not. Is
there a possibility that sky may fall down and the sun may fall down on the earth? Yeah, sun may fall down on earth. That doesn't mean that, I'm not having coffee right now. I'm not running away anywhere. So is there a possibility? There's always a possibility. I mean, if that is going to happen, let the sun fall down on the earth, I'm good finish. But don't just file the premium processing. No reason for it. But there is something completely odd with your company. There's something completely odd. And I don't understand what it is. I don't.
Sure. I mean, maybe I'll get more details, and maybe should I?
Yeah. I mean, you can. One thing you can do without contacting a company is you can file something called FOIA, Freedom of Information Act, in USCIS government website. So you will get a copy of the I-140 petition though. So without your company knowing, you can get a copy of the old I-140 application and a new I-140 application. Then you go sit down with a lawyer. Then the lawyer will tell what is going on with the I-140. because dal mein kuch kala hai. That is exactly what it is.
Okay, understood. I'll get maybe I'll try to get
that's
more details
better
around that and let me share the premium process. Thank you. Thank you so much for your advice.
Thank you.
Thanks, sir. Thank you for calling.
Thank you, ma'am.
Rahul Garu, we have one question from our viewers. This is from Nitin Soma. He says, what happens to my status if my H1B extension with company A is denied? It says it's due on March of 22, while my part-time H1B with company B has been approved till 2024 of Feb.
If your extension with company A, which is approved until March of 2022, if that gets denied, you cannot work with the concurrently filed H1B. Unfortunately, you cannot. You will be out of status if it passes through March 2022 and you got the extension denied with company A, which is a full-time, and the second company is a concurrently filed H1B. You cannot continue working concurrently filing until 2024.
Okay.
You can do one thing. I mean, the best solution for him is that to get the decision before March of 2022. In that way, he has one other chance of filing an extension. The second chance is that before March of 2022, the company B, which has only part-time or concurrent filing H1B, they can convert into full-time and change it to their company too if they want to.
That's a good option, Rahul Garu. Thank you so much, Andy. And on that note, we'll just go to our next caller. So area code 703, we're ready for you now.
Yeah, hi. Can you hear me?
We can hear
Yes.
you. Go ahead.
Yeah. Hello, Rahul Garu, and hello, Nitin. Good afternoon.
Good afternoon.
Yes, sir.
So my name is Sampath. I have like a couple of questions. I filed this like a downgrading from EB-2 to EB-3, and like I got the receipt, and I'm just like I have a couple of questions regarding if I get like EAD and advanced payroll. So can I, before my 140 got approved, can I change the employer? Like if I get a nice full-time opportunity or something like that, can I do that?
It's a yes and a no though. But here is the thing though. If you move to company B, the company A withdraws the I-140, then they may 95% of the time deny the 482 application or 99% of the time. Then you have to go to a federal court to get it reinstated, or you can file a motion to reconsider. It's a nightmare.
Okay.
I would suggest that unless you want lawyers to have houses like this at the back of it, which is a fake one for me, for some lawyers it's real, I would wait until I-140 is approved.
Okay. And the second question is like related to like doing the premium processing for I-140 approval.
Absolutely.
Some people say that like, so I mean, it's like the people are like, there is a myth or like there is something going on. A lot of people are getting denied if you are in a place where your previous 140 was not there, like the EB-2 I-140.
No. It's not getting denied. That's a wrong word. It's getting rejected. There's a difference. I'll tell you the difference. Rejection. Yeah. So rejection means not denial. What they're rejecting is they're summarily saying, we rejected, file it in 1 month. Okay. Your $2,500 is stayed. They didn't take your money. And we are refiling it. They're accepting it. So what did you got to lose?
Okay.
You just have to pay extra money, FedEx, for your lawyer. Our office doesn't charge extra money for FedEx, but if your lawyer is charging, I don't blame him. You're just paying one other extra. Put it back again. They're accepting it. So the rejection is not having any impact whatsoever at all. Your money is not lost. If they reject, you file it again. If you reject, file it again. There are things that we have done 3 times, 4 times. Eventually, it got accepted. So you should do the same thing.
Okay.
You don't do it in your case.
Okay. So, I was in assumption that rejected means like that downgrading option is completely gone.
Good you asked the question. Okay. Good you asked the question. Good I clarified it. It is only they're giving your money back. You give them back, give them back. Sometimes they'll take it.
Okay, gotcha. So it's like they're just rejecting that piece of premium processing. not the whole application. Something like
you are right. You're right.
Okay. So once you file that and then just wait. Okay. Thanks. Yeah.
I mean, if we get rejected, let them file again. Rejected, get them file again. I mean, we just put in the FedEx next day, same day sometimes.
Okay. Sounds good. Yeah. Makes sense.
Thank you.
Thanks. Thanks for that.
Thanks for calling in. So folks, we have so many more callers, so many more questions, so many more messages waiting on Mata, but we are all out of time today. I'm sorry, we do try to extend the show to help as many people as possible, but we do have an intent. So Rahul Garu, thank you so much as always to help so many people, guide them in the right direction. We can't thank you enough here at TVASIA Telugu channel to be such a pillar of the community and to willingly help people in such a day and age. And we look forward to seeing you back here next week, Rahul Garu. And to all our viewers, please make sure you tune into the same show, same time next week, and we'll see you all then. You have a good week.
Thank you very much.
Thank you, Andy.